Donc, sans plus tarder, je vais laisser la parole à Dishna qui, bien évidemment, nous parlera du Children's Act qui a été promulgué aujourd'hui. À vous, mesdames.
Bonjour à tous, merci beaucoup de nous joindre aujourd'hui. Je vais partager mon écran avec vous puisqu'on a fait une petite présentation pour les besoins de cette conférence. Et la présentation se fera en anglais pour éviter de dénaturer les provisions de la loi. Mais éventuellement, bien sûr, si on a des questions, etc., on peut switch au français. Donc, je vais vous partager mon écran. Wait until the end of the presentation to ask us your questions. So, let's begin. So, the legislation that is being proclaimed today is made up of 3 acts. It is the Children's Act, the Children's Court Act, and the Child Sex Offender Register Act. Together, these 3 acts constitute a reform of the law concerning children's rights, children's protection, and even children's prosecution in Mauritius. Previously, some of these issues were dealt with in the Child Protection Act and the Juvenile Offenders Act, both of which are being repealed through the proclamation of these new legislation. There are certain provisions regarding children that are still found under the Code Civil Mauricien. Some of these provisions are still relevant, some of them have been amended by the new legislation, and others have simply been repealed, as we will see during our presentation. These new acts were passed in Parliament in December 2020, and they are now, today, being given effect by way of a proclamation. Essentially, these new acts ensure that the laws of Mauritius are more or less compliant with the UN Convention on the Rights of the Child, as well as the African Charter on the Rights and Welfare of the Child, both of which Mauritius is a signatory to. Let us begin by addressing certain important or interesting provisions of the Children's Act. So the Act creates a best interests principle in respect of children. What this essentially means is that any person, any authority, or any office dealing with a child must act in the best interest of the child. There are a number of things that the Act provides for, such as that person must respect the child, they must treat him fairly, they must take his views into account, and they must inform the child of any decision taken in his regard. The principle itself is quite far-reaching, and there may be other things that a person will be expected to do when dealing with a child, depending on the circumstances. Another interesting provision is the one that gives a child a right to privacy, which protects the child's identity, his name, his image. The Act also gives children a right of participation in matters which concern them when they have the required level of maturity. Importantly, the Act also prohibits child marriage, so that children of more than 16 can no longer marry, even with the permission of their parents or of a judge, which was previously the case under our Code Civil. It is also stated that a child of more than 14 years old may be held criminally responsible. We will go in detail regarding this issue of criminal responsibility later on in the presentation. Let us now turn to the Children's Court Act. which is the second act that is being proclaimed today. So the title is pretty self-explanatory. It establishes a children's court, which is made up of two divisions. The first division is the protection division, and the second one is the criminal division. The protection division is able to hear and determine applications for care and protection orders, which are detailed in the Children's Act. The criminal division will try offences which juvenile offenders are suspected to have committed. One new and interesting aspect is that the protection division is actually empowered to make a factual finding regarding children who have serious behavioral concerns. So parents who are raising a child who exhibits serious behavioral concerns will actually benefit from help from the authorities when dealing with such children. If the help that is being offered to the parent is not sufficient, then eventually the child may be placed in an institution to help with these concerns. Let us now move on to the Child Sex Offender Register Act, which is the third and the last piece of legislation that is being proclaimed today in the context of this reform. So this basically provides that there will be a register that will be kept of all registrable offenders. Those are the people who have been found guilty of sexual offences against children. This register will be kept by the Commissioner of Police, and there are certain restrictions that are imposed on these offenders, such as certain movement restrictions. Right, so now that we've seen what these three pieces of legislation address, let's go back to the Children's Act and let us see what type of acts it criminalizes in respect of children. These acts include the more typical offences, such as ill-treatment of a child, abandonment, abduction, sexual abuse, mendicity. But what is interesting is that it also creates certain new crimes, such as cohabitation between minors, bullying, and child grooming. What is child grooming? It is a situation where an adult uses certain techniques to gain the trust of a child and to create a relationship with that child with the ultimate aim of obtaining sexual favors from that child. This is a phenomenon that is quite frequent nowadays, with young children having access to internet. And it is commendable that the Act addresses this and criminalizes this. Let us now talk about an institution that has been set up under the Children's Act, which is the Child Services Coordinating Panel. This panel, which is made up of 11 members from different ministries, such as the Ministry of Education, Ministry of Family Welfare, Ministry of Health, etc., will be in charge of ensuring that the Children's Act is properly implemented. The aim of this panel is coordination of services at an inter-ministerial level. As of now, we do not know how it will operate vis-à-vis this Child Development Unit or the Family Protection Unit, but it does have very wide powers under the Act. So it is interesting to see how it will function in practice. Another new item, novelty item under the Act is the Child Mentoring Scheme. So a child mentor can be appointed by the court, and this person will operate under the Child Mentoring Scheme. He or she will assist children between the ages of 8 to 16 and will provide them with help regarding their lives. He or she will advocate for the interests of these children. Of course, this mentor will need to meet certain requirements. And of course, he will have to submit reports to the ministry regarding the work that has been accomplished with the child and any progress that has been made with the child. A similar type of arrangement is the appointment of a guardian ad litem. This is a person who's also appointed by the Children's Court to represent and advocate for a child's best interests during the course of court proceedings. Now, when we say court proceedings, this arrangement, the appointment of a guardian ad litem, is not limited only to child victims. It can also be for a child witness or even a child offender if the court deems that these children will benefit from the appointment of a guardian ad litem. So now that we've gone through the different acts, the important provisions of the Children's Act, and we've also seen the types of authorities that have been created, let's turn to a specific issue, which is the age of criminal responsibility for children. As most of you may know, this has been the subject of much debate, as certain people consider this to be too young an age. So essentially in the Act, the child can only be prosecuted for a crime if he or she is older than 14 years old. If the child is younger than 14 years old, then they will be assessed by a probation officer. This probation officer can choose to send them to counseling or therapy, and a plan of intervention will be devised for this child. Now, if the child offender is 14 or older, then he or she may be prosecuted, much like an adult. Although the child will need to be assessed by a probation officer before he or she is prosecuted or appears in court. Interestingly, if the Director of Public Prosecution deems it appropriate, the child may be enrolled in a diversion program instead of being criminally prosecuted. This program is a non-residential supervision and rehabilitation scheme. However, if the child is ultimately prosecuted, he or she may be detained or even imprisoned. Although there will be a pre-sentence report from a probation officer before he or she is sentenced. So I think we've covered quite a bit of ground regarding these acts. Unfortunately, we cannot go into much detail regarding all of these provisions, as this will take us quite a bit of time. These are quite lengthy acts. But we try to give you an overview of what the acts are, the type of changes that they bring and their objectives. So now if you have any questions regarding anything we've touched upon, I'd be happy to try to answer them to the best of my ability.
Merci, Dishna. Merci pour cette présentation. Comme on sait que les médias sont très occupés ces temps-ci, donc on a regardé la présentation en assez court. Et maintenant, on peut prendre des questions, et les questions en français sans problème.
Bonjour,
Bonjour.
c'est Yacine Denmamud de l'Express. Vous avez évoqué le Child Services Coordination Panel, et puis vous avez fait ressortir vous-même qu'on ne sait pas jusqu'à présent comment est-ce que l'interaction sera avec la CDU.
Oui.
Justement, le fait d'avoir gardé la CDU ne va pas poser problème ou être un hindrance au fonctionnement de ce nouveau panel?
Alors, ben si, déjà pour la question, qui est très intéressante, et je pense, personnellement, je pense que ce sera une question de planning. et de regulations. Parce que n'oublions pas qu'un acte tel que le Children's Act va nécessaiter des regulations, va nécessiter certaines practice orders du ministère de tutelle. Et je pense qu'une fois que cette interaction entre les différentes autorités sont suffisamment adressées dans ces regulations ou des practice directions, etc., je ne pense pas qu'il y aura un problème sur le fond. Parce que, quoi qu'il arrive, n'oublions pas que le principe de base, le principe chapeau de toute cette loi, c'est l'intérêt de l'enfant. Donc, il s'agit quelque part de venir peaufiner certaines choses à travers d'autres instruments légaux pour s'assurer que le fonctionnement de ces institutions-là n'empiète pas les uns sur les autres. J'espère que ça répond à votre question.
Oui, merci.
Est-ce qu'on a d'autres questions?
J'aurais une autre question concernant le registre de Child Sex Offenders. Est-ce que ce sera rétroactif?
Alors, par contre, ça, ce n'est pas prévu dans la loi. Laissez-moi juste vérifier pour ne pas dire de bêtises. Normalement, une loi n'est jamais rétroactive. Donc, mais là,